This is Professor McDonald, and this will be some professor comments from Chapter 2. The title of this chapter is Rules of Evidence and Arrest. Now, the good thing about this chapter is this should be a review for most of you. You probably have taken the Intro to Criminal Justice class, criminology, and hopefully you've taken criminal law. But if you haven't, it's still okay, because this will be something you can learn now, and then it'll give you a benefit later on as you take some of your other classes that'll connect in with this. I know with criminal procedure, you'll cover a lot of the same items that we're going to cover in this particular chapter. Now, the whole key thing relative to evidence is simple. You want to collect evidence because that's the only way you're going to be able to connect an individual to a crime, and you want to collect that evidence lawfully, because if you don't, you won't be able to use it. No evidence is admissible in a court of law unless, number one, it's relevant to the crime. You have to connect it between a fact offered in evidence and the issue to be proved. So let's say, for example, if I'm working a robbery case, and one of the key issues is evidence that helps identify the suspect, and maybe I have a videotape at the bank where he robbed it, and we can identify that individual. Well, that evidence there would be relevant. Number one, it's relevant to the case. Number two, there's a connection between that videotape and a fact offered in evidence and the issue to be proved. In other words, we're trying to prove that this guy was the individual that robbed the bank. And it also has to be material. It's got to relate to the investigation that you're conducting. And the key thing about evidence, too, it's got to be lawfully obtained. And this comes into play particularly when you're conducting search warrants, developing probable cause to get a search warrant. You got to make sure that you have the probable cause is lawful, and it does establish that authorization, excuse me, that allows you to present the facts to a magistrate and get the search warrant to help you recover evidence connecting an individual to the crime. Now, it's important to remember that the Fourth Amendment of the Constitution, which is part of the Bill of Rights, provides protections against unreasonable searches and seizure. So we can't just go in and search a person's house without a lawful legal justification. Now, there are exceptions to that in the sense that you don't always have to have a search warrant right there in your hand, but we'll talk a little bit about that. But for the most part, before you can search an individual or search a person's house, you have to establish probable cause. And you have to present an affidavit to a magistrate at the local, state, or federal level. And you have to swear that the information contained in that affidavit is true. And then you have to convince that judge that you have enough probable cause. Probable cause being an accumulation of facts or circumstances that would lead a reasonably prudent person to believe that a crime has been committed, and the fruits of that crime exist at a certain location, which is the place that you want to search. Now, when you apply for that search warrant, you also have to swear through oath or affirmation that the information in there is true. You cannot perjure yourself. That's a quick way to get fired and also a way to get arrested. So whatever you provide in there, it's got to be truthful, and you might not have enough probable cause, and the judge will tell you that. The magistrate will say, hey, I'm sorry, you don't have enough here. You got to do some more work. Those things do happen. And of course, when you get a search warrant, it's got to be very detailed as to what you're going to search, what you're looking for, that sort of thing. There are times when you can do a warrantless search. In other words, let's say one just comes to mind real quick. An individual, it could be an emergency situation. Maybe a person just robbed a bank and you're in hot pursuit, and you catch that individual and you know he's got evidence on him and possibly a weapon on him. Well, you can search that person. You're not expected to hold that person in that location and then go get a warrant to come back and search that person. That would be a warrantless search, okay? You have developed probable cause. You know, this person's been identified as the robber, you're in hot pursuit, the crime just occurred, you have probable cause. If you went to a judge and explain that to him, he would say, yeah, you do have probable cause. But in this case, you don't have time to go get a warrant. Now, what will happen is there'll be a hearing later on. It's called a probable cause hearing, and you'll have to explain to a judge why you felt you had the right to either arrest that person or search that person or whatever. But there are times when you can conduct a search with a lawful and you do not have a warrant in your hand. Again, that could be there's different types too. A consent search, you can ask a person for consent, and if they give you consent, you don't have a warrant, that's lawful. But just remember this might be a good question. A person has an absolute right to refuse consent search when asked by the police, and they may revoke it at any time. So let's say you make a traffic stop and you're suspicious of this individual in the car, you ask him to step out, and you don't have probable cause to search his car, but you ask him for consent and he gives it to you. Well, now you start searching and you find evidence of a crime. You can arrest that person and seize that evidence because he gave you the consent. Now let me give you another scenario. You stop that person, the same person, you ask for consent and he says okay and he gives it to you. And in some departments, verbal's okay. Sometimes you have to get that in writing at the scene. And then as you start searching and he says, hey, I've changed my mind. Well, you got to stop. Okay? Now here's what can happen. Think of this. You're searching, you stop the individual, you don't have probable cause, but you think something's up for whatever reason. You ask for consent to search, and as you reach under the back, or you look under the back seat, you see what you suspect to be illegal drugs, and then he yells, I'm withdrawing my consent. Well, what are you going to do at that point? You've just seen it in plain view, okay? So in that case, there's a couple of ways you can go. Normally what you would do is call the prosecutor and ask him which he prefers. You can arrest the individual, detain that individual, go get a warrant, or he might say because it's in plain view, you can go ahead and seize it, okay? And then now you have probable cause because of what you found to search the rest of the car and to arrest the individual. And again, the plain view exception permits investigators to observe and seize evidence without a warrant if the officer is lawfully in a position to view an object, and if the incriminating character of the object is immediately apparent. So if I know this is drugs, when I started in a consent search, as I just gave it to you, okay, and I know this is drugs, then I can seize that under the plain view exception. Here's another thing. Let's say I'm pursuing an individual on foot and he runs into a house and I run in after him. Well, I'm in that house lawfully because this guy just committed a crime, and I look around and I see drugs laying on the table. In addition to effecting the arrest of him, I can also seize those drugs. Okay? And so this would be evidence in plain view. And they talk about it in the book. They talk about stop and frisk, and that's normally to stop and frisk you have what they call reasonable suspicion. You have an idea that maybe a crime is about to be committed, and you have a reason to stop. You can't just stop and frisk people without some sort of suspicion, and the definition they give you is reasonable suspicion. When you arrest an individual, you can search that person. It's called search incident to a lawful arrest. I've done it 1,000 times. And so if I have a warrant to arrest an individual and I see him on the street, and I approach him and I have my partner with him, and we arrest him, we can also search his person, okay, to gather whatever it could be, whether it be weapons or contraband or whatever. The Supreme Court says that you have a right to search that individual. And normally, the scope of that search includes the person, his wallet, a purse if it's a female, or anything within the immediate area of that individual. If you arrest somebody in a car, within anywhere where he can reach, okay? Now, they also talk about vehicles, okay? Let's say the U.S. Supreme Court has created an exception to the warrant requirement for motor vehicles due to their mobility. In other words, because vehicles can leave the scene so quickly, if a police officer develops probable cause, there is a motor vehicle exception, okay? So in other words, let's say, give you an example here. I'm a state trooper. I pull a guy over for speeding. As I walk up on the vehicle and I look in the back seat and I see a sawed-off shotgun, which is illegal. It's unlawful to have and possess. I now have probable cause to arrest that individual, seize that shotgun, and search that vehicle. I don't have to wait and go get a warrant and then come back. The Supreme Court has given that authorization. And they'll talk in the book, and it's not just the back seat. You can search the entire vehicle. Now, open fields, if let's say there's a crime that occurs and the person is running through an open field, let's say on campus, well, you don't have to get a search warrant if he throws something out of his pocket while he's running on campus. That's an open field. There's no expectation of privacy for that. One of the last things I want to talk about is the exclusionary rule. This is very, very important. The exclusionary rule, think about exclusion, to exclude something, is applied when investigators violate a person's constitutional rights by conducting an unlawful search and seizure. This rule prevents illegally obtained evidence from being admitted into evidence against an individual. Okay? So it's a very important rule, one of the key rules established, in particular with the Weeks case, Weeks versus the United States case, which is about 100 years ago. So what it means is that if you do an investigation as a criminal investigator and you seize evidence unlawfully, in other words, you search an individual or you stop a vehicle without probable cause and search the vehicle, you're not going to be able to use that evidence. You just wasted your time. You can't use it because the court is not going to allow you to use that evidence that was obtained illegally against an individual in court. And even more damaging could be an extension of the exclusionary rules, the fruit of the poisonous tree doctrine, which holds that evidence derived from an illegal search or seizure is inadmissible because of its original taint. So let's say I stop an individual unlawfully, okay, and I arrest him, and then I start searching his car, okay, and then I open the trunk and there's a dead body in the trunk. I might not be able to use that dead body against him in a murder case simply because the original stop was unlawful and the search of that trunk was derived from that original stop. That's kind of the worst case scenario, but I'm just trying to get across evidence that's derived, or you do an unlawful search of an individual, you recover a key to a storage shed, you then go unlock the storage shed and you find drugs in there. Well, if the original search of that individual where you found the key was unlawful, then any evidence that's derived from that unlawful search, you being able to find out where his drug stash was, you're not going to be able to use that either. And these laws are meant, the exclusionary rule was created to punish the police for violating individuals' rights. When is a person arrested? Well, when they feel like in their mind that they're not free to leave. They talk about the different encounters, and I'll let you read that on your own. But if a suspect believes that he's not free to leave, and if any reasonable force has been used to detain that person, then by all legal definitions, that person is under arrest. And so he must be treated in that manner. Now, it's one thing to stop a person on the street and say, hey, are you a witness? Did you just see that robbery? That's not an arrest. But it's another thing to stop a person, ask them to come to the police station, and while they're in there, start questioning them about a crime. In that person's mind, if he feels like he's not allowed to leave, then in his mind he's been arrested and he'll have to be treated as such. For example, if you interrogate that person, he would be entitled to his Miranda rights. So there are some discussions about that. Locating suspects, broadcast alarms, I'm not going to go through all that. You can read that yourself, but let's alert officers if you come across a crime, maybe somebody just robbed a 7-Eleven, and the first officer on the scene gets a description of the car, he would broadcast an alarm to the other officers on duty and other law enforcement organizations in the area as to the description of a vehicle that was involved and any description of any individuals involved in a recent crime. Just like you have to have probable cause to search a person's house, you must also have probable cause to arrest somebody. Okay? So, and there's two ways to arrest an individual. If an individual commits a crime in front of you as a police officer, or you observe it, you can arrest him. You don't have to get a warrant. Or if a person has committed a crime, he's been under investigation, and the investigators have gone to the judge and obtained an arrest warrant for anybody that locates this individual to arrest him and bring him to the court of jurisdiction, then that would be an arrest as well. But the bottom line is this: just like you have to have probable cause to search a house or a car, you also have to have probable cause to arrest a person. And remember, that search incident to arrest, if you find something on that individual, that can lawfully be seized and used against them in court. Now, there's certain things you can't do. The search of a person should not verge on conduct that shocks the conscience. I like that because they use that terminology in the textbook. In the case of Roshan versus California, where they pumped an offender's stomach out in order to recover 2 capsules of heroin. The court's not going to look too kindly on that. It definitely appears that the police officers in that case went way too far. One of the other items they talk about here, I'll just mention quickly, is the corpus delicti. They call it the body of the crime. It's not like a homicide body, so you understand that. The body of crime, what it means is, what are the elements of the crime? What are the things that make that a crime? How is the law described that makes this a crime? So, for example, in a murder case, the elements of the crime of murder would be a first-degree murder would be the unlawful killing of a human being with premeditation. In other words, with planning and a forethought. Well, that would be the corpus delicti, would be to prove that an individual, number one, is dead, and that another individual caused that death through planning and premeditation. That's what they mean by the corpus delicti. The prosecutors have a lot of say-so in investigations. They're the ones that make the decisions on whether somebody gets charged or not. You always have to remember that, so it's important to have good relationships. The remainder of the chapter is very simple. Hopefully some of the items that I've talked about on this tape will be useful to you in your readings and understanding of the material. This will end this dictation.